Hi, I'm Jim Cunningham, and we're going to talk about maintaining family harmony when you're gone. And we're going to talk a lot about money. What does it mean to you? What is your legacy? Is it money? Is it something beyond money? Mine and my family happens to be education, and that's one reason we do these videos. How do you preserve your legacy when you're gone? We're going to cover 7 strategies, from who's in charge of your stuff when you die, to disinheritance, to advances on inheritance, undue influence, divorce of heirs, all sorts of juicy stuff. And we'll also have 5 action items that you can take. Hi, this is Jim Cunningham, and we're going to talk about the top 7 estate planning strategies to guard family harmony. So if you've been through this before, or you might be concerned about it, is everyone going to get together for Thanksgiving when this is all over? About seven kind of topics to think about to promote family harmony. Or is people just going to argue forever? And that happens. You know, we see that in families. And when people are making their estate plan, you know, when I meet with a person and it's about the money for a lot of people, but for a lot of people, it's about, you know, I want these people to continue to love each other after I'm gone. I want people to be able to get together, you know, as I said, at Thanksgiving. And that's really kind of the theme of this, is how do you preserve this? We have another strategy, it's a little ad for our next webinar. So if you're watching this, it's probably the webinar after this one. This is the income tax planning issues and how to avoid the 9 most common income tax planning traps. I'll cover that with Phil Wilson of Markham. I'm an attorney, Jim Cunningham. I'm a partner at Cunningham Legal, 25 years plus experience. We have offices throughout the state of California. We help clients in other states. I'm a certified specialist in estate planning, trust, and probate law, and securities insurance licensed, and a pilot. These are the lawyers currently in our firm that we have. And there's my law partner, Rochelle Warner, and the other associates. This is a disclaimer. I'm going to talk about stuff. This is not legal advice. I'm going to talk about a lot of legal concepts. This is not a substitute for legal advice. So basically the bottom line is, don't watch this and go out and do a bunch of stuff based upon what you're seeing here. So, you know, I want to start this with a little bit of emptying your mind. And what I mean by that is, you know, fundamentally what we're talking about here, what you leave behind can be quantified in terms of dollars of wealth. And that's, you know, that is something, we live in a world where people disagree on a lot of things, right? And people look at each other like, how can we disagree on that? I don't see what you're saying. Everyone agrees that, you know, $1 million is $1 million. And I saw Steve Forbes speak several years ago in the pre-COVID world. And he said, money has no intrinsic value. It is a measure of wealth. That's all money does, is it measures the value of something. So there's nothing particularly intrinsic about money. And money means different things to different people. Now, what do I mean by that? Some people, when they say they don't care about the money, a lot of times that's all they care about, right? So somebody says, it's not about the money. As a lawyer, that's a huge red flag, because it typically is. Some people view wealth as theirs. You know, if you're the kind of person who says, listen, I've got kids, but I worked hard. I don't want to spoil them. I think it's good for them to work hard. This is my money. I'm worried about outliving my money. I'm not sharing it with my kids while I'm alive. I would say that's perfectly valid, right? On the other hand, you might be a person who says, hey, my basic needs are met. I feel like I'm not going to outlive my money, or my kids need it more than I do, or whatever the case may be. And it's perfectly valid to share it with other generations. So what I mean by money means different things to different people is you need to figure out what it means to you. You need to figure out what you want your legacy to be. And for many people, the legacy, in fact, is not money. It's other things, right? A legacy of promoting education in the family. That happens to be in my family. That's one of our main legacies, is education. Obviously, that's why we do these webinars, is to educate you. So it means different things to different people. And somebody may have a different attitude. They may place a different value. They may see money as highly utilitarian, meaning getting them what they want. Other people may see it as a source of safety, whatever it is. But I've broken this down into 7 essentially strategies, right, that really address these real central questions and issues. One is, who's in charge of your stuff when you aren't? This is a big deal, right? And so what this means, we'll talk about what this means, but you know, one day you're not going to be in charge of your stuff, of your assets, your money, your cash, your healthcare decisions, right? Somebody's going to be in charge of that. That is a source of family conflict. Disinheritance. We'll talk about disinheritance. That is absolutely a source of conflict. Advances on inheritance. You can see how, if you want to leave it equally, but somebody gets something before you die, does that come back in? Do you have to pay that back? We'll talk about that. Undue influence of others. All right. Meaning I'm not talking about undue influence on you if you're the person who is leaving the estate plan to the kids. What I'm talking about is maybe a son-in-law or daughter-in-law, that undue influence on a child. And we'll talk about an example of that. Statement of intent in a trust. I would say this is in the optional category. And we'll talk a little bit about that. Basically, it's saying what the purpose of a trust is or what the purpose of an estate plan is. We'll talk about that. Protecting inheritance from divorce. I am not talking about your divorce, okay? I'm talking about the people who inherit from you, or if you're the one inheriting, I am talking about your divorce. But what I'm talking about here is people with inherited money. How is that treated in divorce? Can it be protected? When can it be protected? What can be done? And that can promote significant family disharmony. We'll talk about examples of how that might promote harmony. And then we'll round it out with the trust protector and independent trustee. Those are great tools to avoid family disharmony. So who's in charge of your stuff when you die? So here's what I'm talking about. You may have heard the term executor, successor trustee, agent under a durable power of attorney, attorney in fact. Attorney in fact is not a lawyer. It's really an agent, right? So those are interchangeable. So this is somebody who makes decisions on your behalf while you're living or after you've passed away, sort of on behalf of your assets, on behalf of your trust. That would be a successor trustee. Here's one thing I see people go, I don't know, I'm going to name the oldest kid. Well, that may or may not be a good idea. There's a concept in the law that I learned in law school from my property professor, Professor Quadras, white of heart and empty of head. And that's a concept from, I don't know, probably 500 years ago, 400, 300 years ago in English law, meaning this was a really nice person, a good person, an honest person, but they don't know what the heck they're doing. That's really not a good person to name because a lot of this is very technical. Now, when it comes to healthcare decision-making, that might be appropriate. But when it comes to managing finances, when it comes to accounting to other people for the money that is in their name as trustee, right? Because when you become trustee, your name as trustee goes on those accounts. You have to account for every dollar. So it's no different than a bank account. When you get your bank statement, it says at the beginning of the bank, at the beginning of the period, this is how much was in your account. This is what came in. This is what went out. This is what's left over. That is basically an accounting, what I'm talking about. And that's a pretty complex process. Okay. So, and there's a range of complexity on that, but you can see that could get pretty complicated depending on the nature of the assets in the estate. But you fundamentally have three choices. When it comes to naming someone to be in charge of you and your stuff, when you're not in charge, this is while you're, if you get hit by the ice cream truck and don't die, you're what we call incapacitated. You can name a family member. Many people will name their spouse. Fairly logical, not always appropriate, right? But fairly logical. A spouse may have a cognitive impairment, and it would not be a good idea to name that spouse. So family, typically kids, maybe nieces, nephews, grandkids, sometimes a friend. Now, the friend category is somebody who who you have some type of relationship with, somebody that you trust, a personal relationship. And again, this may not be the most suitable person. It, in fact, may be the most suitable person, but that is an option. And then a trust company or a trust bank. And I would also put in there private professional fiduciary. So we've covered this in other webinars, but a trust company is typically a non-custodial institution. So there are two types of trust institutions. A trust company does not hold onto your assets. Those are housed at a different institution. And then there are other trust banks where they do banking, where you can walk in and get cash, for example. And they're kind of a mashup of a trust bank. They're a mashup of a trust company and a bank, and hence the term trust bank. There's also a private professional fiduciary in California that's regulated by statute. And you can go on the private professional fiduciary website and get a list of private professional fiduciaries. So there are different people for different roles. As I mentioned, successor trustee, executor, attorney in fact, and agent. That is no different than soldier, sailor, airman, or Marine, right? Those are the same roles, but we use a different word to describe. So in the military, we use different words to describe the people in those different branches of the military. Same thing here. When I say successor trustee and executor, they're fundamentally filling a similar role. Okay, so much like an airman and a soldier would fill a similar role in their respective organizations. So let's look at an example. Hal and Wanda create a revocable trust and name the 3 kids to serve jointly. So they didn't name the first. They're like, well, just name all 3. It'll be a great party. So who's in charge? You have 3 people. Is it majority? Does it have to be unanimous? Can one run off and do things? The answer is yes, depending on the context, right? It just depends on what the documents say. It depends on what the rules of the institution say. You know, many institutions, they'll say if there are 2 trustees named, we will not require 2 signatures. If you go to sell a piece of real property, the title company will say, we need both signatures. So in the real world, it depends on what you're doing. It also depends on the terms of the document and what the institution's policies are, okay? What if one stops being trustee and you're left with 2, you know, and they don't agree, right? So I'm not giving an answer here. I'm suggesting that you need to have mindfulness on this, and you really need to think about, okay, well, if there's 3, and I know these 3 people, like I'm going to name 3 because these 3 people don't get along, that's really probably not the best solution. If 3 people don't get along, you may want to go to a friend, like, thanks a lot, the friend's going to tell you. You may want to go to a friend. At that point, you may want to go to a private professional fiduciary or a trust company or a trust bank. So another example, Doug names his 3 children in the order of oldest to youngest as successor trustee, so that when Doug stops being trustee, Al serves, and then if Al can't serve, Bob serves, and if Bob can't serve, then Carol serves. But what if Carol is the closest, most able, and least likely to cause conflict? What if she's the one, the peacekeeper in the family? It might not make sense to name Al as first trustee. It might make sense to make Carol as trustee. Now, in your family, in your situation, that may require some type of an explanation. That's where the statement of intent comes in, and we'll talk about an alternate. So you're making clear your desires on what happens when you're not trustee. So disinheritance, we have a webinar on the fine art of disinheriting a beneficiary. I would just suggest that you think twice about a disinheritance. And I'm going to, as we go through the examples, I think you'll see why you may want to think twice, because you won't be around when these people inherit. If they inherit unequally, what I mean by disinheritance is you have 3 kids and you leave everything to the 2 kids and disinherit the 1 kid. That's what I'm talking about. There's an axiom in law that the law abhors a forfeiture. So what that means is there can't be this sort of capricious denial of an inheritance. That would be kind of in the class of forfeiture, and we'll have an example on that. Also, the reason, why did you disinherit this person? There are lawful reasons and there are reasons that are not enforceable. The other one is, what will they do when you're gone? I had some clients come in, several children, and one of the children's gay, and that child was disinherited because the parents did not agree with that child's lifestyle, right? Well, the kids came in, they said, we want to make it equal because this is our brother and we love him and we think it's horrible that he was disinherited. So really kind of, again, more mindfulness, think about the context when you're gone. What will they want to do? What will you, this is part of your legacy, right? So think about this. And then we'll also talk about no contest clauses. So Debbie writes in her trust that she's disinheriting her daughter, Diane, because she married a spouse of a different race. That is not enforceable. That is a violation of the equal protection laws under the 14th Amendment. This has happened in the past. This has happened with clients. And the bottom line is that's an unlawful method of disinheriting a person, right? So Dave writes in his trust that until his daughter Daisy divorces her spouse, this is an example from law school, she will not receive her inheritance, meaning Dave really doesn't like his son-in-law. And Daisy, you're not going to be able to inherit unless you divorce him, okay? Will a probate court enforce this provision? No. Nope, because the law favors marriage. So that's another example of an unenforceable provision in a trust. Donald writes in his trust that his son Steve will inherit only when he marries a woman of the Christian faith. That is not enforceable because a court cannot determine what is in someone's heart. A superior court judge is not going to determine that a woman is a Christian or not. So that is a provision that's not enforceable. And when a provision's not enforceable, it's essentially ignored. It's almost like it's stricken out. You put a line through it. And so now it may be that Steve would have to marry somebody. Maybe that's enforceable, that he gets his inheritance when he marries, but the court might strike that of the Christian faith. And Dave, in the Dave case where Daisy had to divorce her spouse, she would just get it probably. And Debbie would probably get it because that limitation is unenforceable. So we have a couple of questions here. So we got a Q&A. Should you leave a minimum to a child rather than zero if they are estranged? Legal problem challenging the trust provisions. Dennis, great question. We talk about that in the fine art of disinheriting somebody. I will say this: if you leave somebody, first of all, you have to acknowledge under California law, if you don't want to leave something to someone, you have to mention that person in your estate plan. This person is my child. This person's inheriting zero. There is no disincentive not to inherit. Meaning there's no disincentive not to challenge the trust. I mean, so what that means is if you give the person zero, there's no incentive, there's nothing to lose. If you give them 100,000 or if you give them 50, maybe they say, I'll take the 100 or the 50, maybe, right? And then there's also a Texas case, I believe an unpublished Texas case that says, if you accept something from the trust, you cannot challenge that. And I've heard at least one Superior Court judge cite that case. So, but again, that's covered in the fine art of disinheriting a loved one. So advances on inheritance. So here's what I'm talking about here. In the world that we live in, there are only loaners or owners. There are only owners or loaners. Now, what do I mean by that? Well, if you buy a share of Apple, right? You're an owner of Apple. You own one share of Apple, so you own that. If you buy a debt instrument, maybe Apple issues a bond, right? And you buy that bond, you have effectively lent money to Apple. There really is no other form of ownership in Western culture. You are a loaner or you're an owner. And a loan has some very specific requirements. So if you're going to loan money, so if this advance takes the form of a loan, under federal law, a loan has to have interest. And the federal government publishes this. It's called the 75/20 rate. And they publish this rate. And depending on the length of the loan, every month those rates change. And you must ascribe an interest to it. Otherwise, it's not a loan. It might be a gift, right? Or something else. And that's where the advance on inheritance comes in. A repayment of principal. So if you borrow money, you have to pay the money back. Not only do you have to pay interest, but you have to pay the principal back and security. So a personal guarantee, a security instrument on real property or other assets. California is one jurisdiction that permits an advance on an inheritance. So it's kind of a hybrid of being a loaner and an owner, right? In that sense, you are advancing the inheritance. So it's a gift that is then deducted from that person's share of the inheritance. Okay. So the example here, mom, she's got $1 million estate. She lends her son $100,000 and now she has $900,000. And the daughter gets $500,000 and the son gets $400,000 when the mom dies, and the note, right? So that note is not so much extinguished that causes income tax, but that note is distributed to him. So if you're a CPA watching this, it's a little nuance on that. It's not an extinguishment. It's not a forgiveness of debt. It is a distribution of the note to the son. So that's a little bit different. So 75/20 rate, you got to tack that on there. So that's if mom is lending. And so let's say Mary wants to help Denise, and we have a whole webinar on this, by the way. I believe it's later this year, maybe early next year. Mary wants to help her daughter Denise buy a home. Very common. I'm in California. I happen to be in Marin County at the moment. The average home price in Marin County is $1.7 million. Most people, if they want their kid to, if they want to see their grandkids and live in Marin, they're probably going to have to be helping their kids out buy a home, typically. Okay. So should Mary give the money to Denise? Should she say, honey, here's the money, go buy a house? Should she loan the money to Denise? Or should she buy the house and let Denise live there? Well, if it's a gift, is it an advance on the inheritance? Or will the estates still be split evenly? So let's say Mary gives $1 million to Denise, and Mary dies and she got $3 million left and 3 kids and everyone gets $1 million. Well, in that case, Denise is ending up with $1 million she got plus another $1 million she inherited. So that's not exactly even Steven, right? It's not kindergarten fairness. This is where the advance on inheritance comes in. If it's a loan, it should be secured by a deed of trust. And there should be interest attached to that loan. And is it amortized loan right? Or is it interest only? Amortized is a little bit of principal payment until that loan dies. That's amortization, right? That's the Latin origin of that word, that the loan is, the principal is paid in pieces every month until the loan's extinguished. Or interest only, meaning interest only for 9 years, which is common. And then at the end of in 9 years, that note is due. Maybe you extended another 9 years with a new note. Depends. If it's an intra-family loan, it's called an intra-family loan. If Mary buys the house and Denise lives there, what about Denise's husband, Hank, right? So Mary buys the house, Denise lives there. Hank is mowing the lawn and, working and paying the bills and living there. And maybe he's keeping up the house. And if Denise and Hank divorce, Hank, he's kind of high and dry. He doesn't own that house, right? So what we do a lot of times with family members, and we'll talk about this in greater depth, many times we will structure this as a loan on a down payment. So Mary might lend, $200,000 on $1 million property. Mary has a note secured by deed of trust. Denise and Hank, they get a loan for $800,000, but Denise and Hank own that property. The property maybe goes up to $1.5 million. Then Denise and Hank get a divorce and go their separate ways. Well, they split that increase in the equity of $250 each, but more importantly, Mary gets her money back. She gets her $200,000 back. If she had just gifted that money to Denise, we're going to see in a divorce case, it still may be split 50-50, but Mary may not be getting her money back. And that's a real important one. She may have effectively given a gift to her former son-in-law. So undue influence of others. Here's what I'm talking about. People get married, they get divorced, and they might get remarried. People are born, people die. Sometimes people die out of order. So meaning your kids might die before you. And don't underestimate. It's a George Bushism. Don't underestimate the influence that a spouse has on someone who is going to inherit. Now, this is a spouse. It could be a friend. It could be, whomever, a lawyer, right? Don't underestimate the power of influence over someone who's inheriting. Max asks, advances on inheritance. What if there's insufficient money in the estate to cover the principal at death? Estate loses value. Max, that's a tough one. That's a tough one. So I think in that case, you would be saying, I'm going to advance you money, but that distributive share is less. I think just kind of thinking quickly, unless there's some refunding agreement or some payback provision, right? I think that the other people will just end up getting less, right? Potentially. And that probably will not lead to a happy Thanksgiving. So when mom and dad die and son gets his inheritance, daughter-in-law files for divorce. This is not uncommon. Is the inheritance community or separate property? It's a good question. It depends on what happens after son gets the check. Let's just say it's a check. So mom and dad die, son gets his inheritance. He gets one of those big checks, you hold up. Not really, it's a little check. Maybe it's a wire transfer. That goes into a joint account. Now I will tell you, under law, just because you put it into a joint account does not instantly make it community property, but that does not bode well for the son. Okay. What if the son keeps the money in his own name? Well, it depends, right? What if son deposits his paycheck into that account? It's probably community property. Because remember, community property, all property acquired during marriage is presumed to be community property, except property acquired by inheritance or gift. So in that case, this is initially presumed to be separate property, but I will tell you, in the real world, separate property can easily be transmuted to community property, meaning it changes the legal nature of the property from separate to community. Son keeping the money in his own name does not guarantee that it will stay separate property. What if son dies during the divorce proceeding? Now, this does happen, more than you might think. If son dies during the divorce proceeding in California, they are still married until that final decree of dissolution is entered, right? So the divorcing daughter-in-law would arguably maybe end up with all the money, some of the money out. It depends on what the estate plan says, depends on if they have kids. It depends, right? I'm just spotting the issues here with you. Once the daughter-in-law files for divorce, can the son protect the inheritance? No, because with a divorce, there is an automatic temporary restraining order. So you cannot transfer property once that divorce is filed. even though son has not filed the divorce, daughter-in-law files it, son legally you'd be in violation of a court order if he's tried to move money around. So that is the scary nature of undue influence, and meaning someone's in your ear, maybe a divorce, whatever it is, pay attention to that. Statement of, well, we have another question here. We'll answer this question. My mom wants to name 2 siblings as co-executors in her trust. However, I hear a bank will not allow a trust checking account to be opened once my mom passes, that we have co-trustees. What are my mom's options? I'm not sure that's true with, it may be true with that particular bank. I'm not sure that's true with all banks. So I would maybe ask a different bank, but the option would be to name 1 trustee, right? Potentially. And so that's something that I think if you called into our office and spoke with somebody, they might be able to help you out with that. Statement of intent in trust. So what are we talking about here? Well, these trusts are legal documents. They're written in legalese. They're written by lawyers for lawyers. Clients, in many cases, they look at this. They're just like, I have no idea what's going on here. I see people's names and I see a bunch of like Latin terms. I have no idea what's going on here. So statement of intent clarifies the purpose of the living trust. It is optional. The trustees, something important to know is trustees must follow the terms of the trust and the purpose of the trust. Trustees cannot deviate from the terms of the trust. And we'll cover that on our last point here with the trust protector. They also must follow the purpose of the trust. So statements of intent can include your intent to eliminate or reduce estate taxes. I think most people want that, protect assets from creditors and divorcing spouses, meaning creditors of beneficiaries and divorcing spouses of beneficiaries, not your divorce or your creditors. Educate trust beneficiaries when it comes to financial management. I mean, a trust is a great vehicle to do that. It creates a structure. It creates some guidelines and some a little bit of like bumper rail guards, like if you're bowling, right? It creates some guidance. It can also provide for a disabled beneficiary. So many trusts, and we're not just talking about living trust, but for many of our clients, they do have a loved one with special needs. And there are special trusts for that, special needs trust or supplemental needs trust if you're outside in another jurisdiction other than California. Preserve the family home. For many people, they say, this family home has been in our family for generations. We want to preserve this family home for the future generations, regardless of the cost, so that the family can enjoy. A lot of times you see this with legacy properties, vacation homes, lake homes, what have you. But that's a statement of intent. The alternative to a statement of intent is a letter that you can write individually. So many times when people are doing something that deviates from the equal split between all people, many times there's a handwritten letter that's written that can go into the trust. Bear in mind, the letter that is written is not part of the trust and tends to be written more to the family members than it is to the trustee. So when you do a statement of intent, it's really a statement of instruction to the trustee, but you may have some very private things, some very personal things that you want to share with people after you're gone that you may not want to put in a trust. And so you can essentially write people a letter, for lack of a better explanation, right? And it's good if it's in your own hand. Not everyone does this, but if you sense that there might be an issue with family harmony, I would definitely consider it. Protecting inheritance from divorce. This is probably the biggest issue here. Community versus separate property. I mentioned that the property acquired during marriage is presumed to be community property, except property acquired by gift or inheritance. And why would you want to stuff the inheritance into the pockets of your beneficiary? The old way of writing estate plans is to say, I leave everything outright to Johnny because Johnny's responsible. Another way would be, Johnny's a little young and we're going to give him half when he's 25 and maybe the rest when he's 30. I've seen some trusts written that say the trustee shall distribute 1/3 to Johnny when he's 25, 1/3 to Johnny when he's 30, and 1/3 to Johnny when he's 35. I don't know what's happening with the rest of the trust, because if you distribute 1/3, you have 2/3 left. And if you distribute 1/3 of that, you see where I'm going with that? And you have something left, it never gets distributed. So I think the idea there was 1/3, a half, a whole. But lawyers aren't the best at math. But it's important to think about this, because I would say the old way is essentially a forced distribution. Here's the money, take it. The new way is protecting the inheritance. And we do that through three different trusts that internally in our firm, we've given them a name. The Inheritance Protection Trust. That's a trust that goes to a responsible beneficiary. And that responsible beneficiary is the trustee and is the beneficiary of the trust, meaning they get what's in the trust and they're in control. That's an Inheritance Protection Trust. A dole it out trust is for somebody who's not responsible, right? Maybe somebody who lacks financial savvy, or maybe is a spendthrift, or maybe somebody that just has no experience with money or might blow it. You say, nah, I want to give you that inheritance, but I want someone else to be in charge of it. And many people come in, they say, I want to disinherit Johnny because he's irresponsible. And so I say, well, do you want him to get an inheritance? Well, yeah, but I want to give his inheritance to his sister because she'll mind it for him, right? Well, what we do then is we still give Johnny his money, but we might make the sister the trustee in that case. So that's something, if you're concerned about the responsibility factor on your beneficiaries, then think about a dole it out trust. Special needs trust is for a loved one with special needs. That's someone who's receiving needs-based public assistance benefits. In California, these laws are changing, and they're changing in a staged manner. If you have a loved one with special needs, I would recommend you seek out an attorney who specializes in this. Our firm, we do specialize in this. The other part of that is if you've already done an estate plan with some special needs provisions, you should revisit that because the law is changing, and the law is changing. It's staged changes this year, next year, and in 2024. So something very important to be mindful of. So here's another example. Remember the son who lost the money, right? Now, this is if mom and dad did some different planning. When mom and dad die, son gets his inheritance, daughter-in-law files for divorce. So same set of facts. So this is a little bit of revisiting what we did on the undue influence of the divorcing spouse. Is the inheritance community or separate property? Well, because mom and dad built into their trust the Inheritance Protection Trust for son, that property never goes into son's name as an individual, okay? It's in a trust for his benefit. The money is not legally the son's individual money where he could make a transmutation from separate to community property, okay? So it's protected. It's like it's in a wrapper. You can give someone a present in a box, or you put wrapping paper around it. You can think of this Inheritance Protection Trust as wrapping paper around the inheritance for the son. Now, if the son dies during the divorce proceeding, it goes to the people that the son wants, not his future ex-spouse, or it goes to the people that mom and dad wanted. Probably not going to be, in most situations, not going to be that spouse. It's going to be the son's kids. So that helps keep those assets in the family. And when the daughter-in-law files for divorce, the money doesn't need further protection because it's already protected, because this inheritance is in this wrapper. Versus here's your check. So the alternative is here's your check. Son puts it in his name. Bad idea. If this inheritance is wrapped in an inheritance protection trust, much better idea, much higher probability of it being protected in the event of a divorce. And so we do have a question here. If you guys have questions, go ahead and put those in. Sharon, thank you for asking your question. To protect my small estate from my daughter-in-law, do I need to have a separate document within my living trust that's already been in place for 15 years? Thank you. Sharon, if you want to protect it from your daughter-in-law, I think this example we went over, and this works for inheritances large and small. And let me tell you something about size of inheritance. Is I meet with many people, and some people inherit $1 million, or they inherit $10 million, and it goes on the pile, and it doesn't really change their life. Some people inherit $100,000, and it changes everything. So I would say that a lot of people think that only big estates need protecting. I think the little ones need protecting too, because for many people, $100,000 is a significant amount of money, and it does allow them to do things that they just need to get done, whatever it is, right? So I would say size is relevant, but I don't think that a smaller estate needs less protection just because it's smaller. It actually might be the opposite. It might need more protection. So let's talk about trust protectors and independent trustees. So this is very important. Now, this is a tool that is used to preserve family harmony. So what's going on here? A trustee is a person, I'm just saying high level. A trustee is a person who is named in a trust instrument, a living trust, and that trustee must follow the terms of the trust. I said that before, right? On this video, the trustee must follow the terms of the trust. But what if those trust terms don't make sense? And I'll give you an example. We had clients many years ago, and they had a ranch in Northern California. And this one son of several sons, one son owned half that ranch. Well, the son and the parents, they sold that ranch and bought a ranch in Texas. And the living trust said that half of the ranch in California goes to the son. But the parents never came in and updated their estate plan. This is why you should update your estate plan. And everyone in the family agreed that the ranch that was in Texas that replaced the California ranch should go to that son who owned the other half of the ranch, right? So they sold one asset and replaced it with another. The problem, the way trusts are written, is when you carve out an asset and say this ranch goes to this kid, if that ranch is not in the estate, then that gift is called it lapses, it goes away. So in this case, I served as trust protector. I got the agreement of all the parties. The trustee could not distribute the half of the Texas ranch to the son. But as trust protector, I was able to talk to everyone and say, oh, well, obviously the intent of the parents, and everyone agrees, was that Texas property should be distributed to the son. So what we did is we changed the terms of the trust, not for evil, but for good. Now, something that's important to understand is, in order to do that, without a trust protector, the family would have had to go to court in Texas because the real property is located in Texas. So, and I'm telling you, if you go to Texas and you go to court, you don't know what county you're going to be in. Well, I mean, yes, you do, because you're in the county where the real estate is located. But you never know what a judge is going to say. Even it doesn't matter what state you're in, they may not agree. That judge may not agree. So I would say that a trust protector is a person who has power over the trust, but is not the trustee. A trust protector is a person who has power over the trust, but is not the trustee. The trust protector also has power over the trustee, but cannot do anything on behalf of the trust. They can just change the rules, right? You're playing Monopoly. The trust protector's there saying, we're going to change the rules, but the trust protector is not playing Monopoly. The trustee is playing Monopoly. Okay, so that's the difference there. I would say only half of estate planning lawyers, right? Only about half of estate planning lawyers are even aware of trust protector or what it is. And only the half that are aware, only half of those people use it. And I would say if you have a continuing trust, like an inheritance protection trust, a dole it out trust, or a special needs trust, we're going to recommend that you have a trust protector. Clients will push back and they'll say, I don't know about this. I don't like this trust protector business. Well, you kind of need it because, as you'll see, a lot of the asset protection strategies that are in these plans do require a trust protector as well as an independent trustee. So what is an independent trustee? Well, trustee, it's a special type of trustee. So all independent trustees are trustees, but not all trustees are independent trustees. For example, in the case where the son is serving as trustee of his trust for his benefit, he is not an independent trustee, right? So an independent trustee is someone who is not related or subordinate under Internal Revenue Code 672C. What that means is no parents, no descendants, no ancestors, no descendants, no siblings, no one who's your employee can be the trustee. So in this case, the son, in order to appoint an independent trustee to do stuff, and we'll cover that in the next slide, that son would appoint a CPA, a lawyer, a trust company, I don't know, his best friend, whatever the case might be, but just not somebody who is in that class of people. It could be a niece or a nephew, because they are not, a niece or a nephew is potentially an independent trustee so long as they're not employed by the beneficiary. So why do we need an independent trustee? Because we may want to distribute beyond health, education, maintenance, and support. An interested trustee is typically limited to making distributions of income and principal for health, education, maintenance, and support. If the child says, I just want it, and if the son says, I just want it and put it in my bank account, he appoints an independent trustee who signs those documents, poof, the money goes into the son's account. The son cannot do that under the Inheritance Protection Trust. So it's a little bit of a wrinkle. And if you're kind of like saying, wow, you went through that kind of fast, I got to hear that again, go ahead and hit the rewind button. And if you're watching this live, this will be posted on YouTube later today, so you can watch it. With a continuing trust, we highly recommend use of a trust protector and an independent trustee. We're probably going to require it, quite frankly, in the vast majority of cases. Now, there are no absolutes in law, but this is probably an absolute one. for us. So when son inherits the property, the trust protector, so let's go back. Let's say son, remember, mom and dad leave the property to son, and the daughter-in-law files for divorce. Well, what do? Well, the trust protector, who oftentimes is me or someone at our firm, an attorney at our firm, removes son as trustee and appoints ABC Trust Company. We'll find a trust company, and we appoint that trust company as independent trustee. And that is really the best creditor protection you're going to get within an inheritance protection trust, because there's a general rule: whatever you can get to, your creditors can get to. So if the son is the trustee, arguably a court can say, come on, you inherited this money, you're the trustee, you got to split that with your ex-wife, potentially. In this case, if ABC Trust Company is the trustee and they say, we are going to distribute for whatever purpose or not, and that's the or not is the key, and that trust company just says, we're not going to distribute anything to son, and that cuts the money off. Okay, so this type of inheritance protection does not exist without a trust protector and an independent trustee. I would say it's time to look at your estate plan and see if these roles are in your trust or not. If you do have a trust that continues on after your death, meaning if your trust says, when I die, money is continued to be held in trust and not distributed outright, you really should consider a trust protector. And you should consider a trust protector even if you have an outright distribution. The reason is you may get hit by that ice cream truck and not die, and you may need to change the terms of your trust, and you're simply not going to be able to do that without going to probate court. And people will say, well, I did a trust to avoid probate, but there is no trust court in California. You go to probate court. So we covered the 7 estate planning strategies. If you have a question, go ahead and put it in the Q&A. Who's in charge? Disinheritance, advances on inheritance, undue influence, statement of intent, divorce. So let me give you 5 action items. So number 1, I think it's time to review your living trust centered estate plan. And if you have a smartphone and you're watching this, or you can get a screenshot, I think this is one that you should really take a picture of and go down this punch list. If you don't have a living trust centered estate plan, find a savvy lawyer who can help you find out if you need that kind of a plan. Because, we talk a lot about living trust. Not everyone needs a living trust, right? It's not appropriate for everyone. It's probably like 95% of the people or 99% of the people we talk to, but it's not for everyone. And I'm not a fan of doing something that's not necessary. There was that Italian philosopher who said, I would have written a shorter letter if I had enough time. I think the lawyer really needs to pay attention to your situation and advise you. And that's something we could certainly do. I wrote the book, Savvy Estate Planning. I mean, we're the firm to contact. Think about what your legacy means to you, and what does your legacy mean to them? Is your legacy money? Is your legacy something other than money? Is it both, right? It may be both. And that's something that I think having mindfulness about that, and also thinking about what that typically the financial legacy means to your loved ones. A tough one too is like, some people say, I have 2 kids and one is really rich and doesn't need the money, and the other one is really struggling. I just want to leave all the money to the one who's struggling. In those cases, many times the parents talk to the kids and they have that discussion. And many times the wealthy child says, just give it all to the poor kid. Because guess what? That wealthy one's going to be supporting the poor one anyway, right? So but sometimes people aren't like that. It just depends, right? And I'm not encouraging you to talk to your family about this. I think this is something you really need to think, because that could stir up more trouble than you would want to stir up. So again, this is case by case, individual. This is really the counseling aspect of being an estate planning lawyer. Is not only what can you do, but what should you do? And those are really, those can be really difficult questions. Be mindful of who will be in control and who is going to influence the people. What I mean by influence, I'm not necessarily in their ear, but influence the outcome of the inheritance. So in the case of divorce, the influence is, half can go to a divorcing spouse, maybe more than half, who knows? And if it's not split evenly, consider a statement of intent or other writing. And this is important, writing. Don't just tell one person, hey, when I'm gone, I want you to tell your 5 siblings, this is why I wanted to do it this way. And it's not really reliable, right? A writing is better. Now you can put that in your trust. You can do it on another writing. So it's strictly up to you. And we have our locations in Northern California and Southern California. And what happens when you call or schedule an appointment? Tell us you want to update or create an estate plan document that if someone's passed away, right? If someone's deceased, there's kind of a fork in the road there. We have two big departments, sort of life planning and after somebody becomes incapacitated or pass away. And please tell us your goals. What do you want out of the engagement? Don't ask for pricing. Only attorneys can quote legal fees. And I know it's a common question and I totally get it. We have our most popular video is how much should a living trust cost? We're going to reboot that for the post-COVID world for how much should a living trust cost in 2023, and that'll be in January. But only attorneys can quote legal fees. So it's really hard. It's kind of like saying, how much is a house? How long is a piece of string? They'll say, well, just give me a range just so I can know. We're going to have that webinar coming up, and I'd really suggest that you take a look at that. And really don't ask for legal advice. Again, only attorneys can ask for legal advice. And the goal of the call is to get your information and set up an appointment with the lawyer. That's fundamentally the point of the call. So when you do call in, that's going to be the expectation. And again, if you need to rewind this and look at it again, feel free to go ahead and do so. Please subscribe to our YouTube channel if you're watching this on YouTube. And if you're not, go to YouTube and subscribe, because this will pop up in your feed and you'll see our almost weekly webinars. And if you enjoy our website, please review us on Google, or if you've had a good experience with us, or if you enjoy our webinars, review us on Google. And I will open it up for questions now. We do have next week, you can go ahead and reserve this and you can scan it with your smartphone and it'll take you to where to reserve, how to avoid the top 9 most common tax traps. These are like year-end tax traps. These are strategies really to think about. And if you're tired of overpaying on your taxes, you really do need to pay attention to that. So keep watching, because we've got another webinar right after this one.